each side will have 15 minutes to present their arguments, and the appellant may reserve up to 5 minutes. We're ready to proceed. I'm sorry. I was just thinking before we began, that's the reason why I was hesitating a little bit. I would just caution counsel, we do refer to this case in Ray DM, so I would caution counsel not to use the actual name because we are videotaping and that goes on YouTube. Thank you. You may proceed.
Good morning, Your Honors. May it please the Court. My name is Lauren Hammersmith, and I am appearing on behalf of DM as the legal intern for the Ohio Public Defender's Office. My supervising attorney, Charlene Boland, is here with me this morning.
Well, welcome. Would you like to reserve some time?
I'd like to reserve 3 minutes for rebuttal.
Thank you.
In 2009, the Medina County Juvenile Court classified DM, a first-time offender, under RC 215282, Ohio's repeat juvenile offender classification statute. The court imposed this classification without the authority of law because it did not find that DM was previously adjudicated delinquent of a sexually oriented offense. This is a necessary requirement for classification under this particular statute. Therefore, this classification is void and must be vacated. And because DM is no longer within the age limits of the juvenile court, the court has lost jurisdiction to reclassify him under the correct statute, which is 215283A. Therefore, we respectfully request that this court reverse the juvenile court's decision and vacate DM's classification. Your Honors, there are 2 important points here. First, a finding of a prior sexually oriented offense is a necessary finding under 215282. And second, the trial court's non-proton entry in this case was inappropriate because it does not accurately reflect what was said in open court. So going to the first point.
When you say it does not accurately reflect what was said in open court, you're talking at the time, at the conclusion of the hearing, and the court said, I find you are, a juvenile sexual offender under 215182.
Correct.
During the time period before that, and we'll review the transcript, obviously, but before that time period, was that statute used?
The only time the statute was referenced in this case was on the October 22nd, 2009 hearing, and I would just direct you to pages 20 and 21 of the transcript. That's where they talk about.
So that was the only statute that was
referenced during 215282 was the only statute referenced during the classification hearing.
Okay, thank you. And what were the page numbers in?
20 and 21.
Thank you.
Was it put on the record at that time that he had not been previously adjudicated a delinquent of sexually oriented offense?
There was no finding made that he was previously adjudicated delinquent of a sexually.
There was no discussion of that at that time either?
No.
On the record?
No. This court has held that a finding of a prior offense is a necessary prerequisite to classification under 2152 in 2 cases, In Re HP from 2008 and In Re AK from 2009. The facts of both cases are pretty similar. Both youth in these cases were 16-year-olds found delinquent of sexually oriented offenses, and it was the case in both cases that it was the first time that they had been adjudicated delinquent of a sexually oriented offense. The juvenile courts in these cases classified both youth as tiered juvenile offender registrants pursuant to 215282 at disposition before sending both youth to DYS. This court held that if there is no prior adjudication for a sexually oriented offense, then a youth cannot be classified under 215282 because it does not apply to that child. The same is the case here. DM was 16 years old at the time of his offense. He was a mandatory registrant. However, the court did not find that he was adjudicated delinquent of a sexually oriented offense because he hadn't been. Therefore, 215282 is not applicable to his circumstances, and the court cannot classify him under that statute. The second point is that this court has held that a non-proton entry is only allowed to correct a clerical mistake so that it accurately reflects what occurred in open court. A non-protunct would be appropriate when the trial court correctly cites the law at the hearing, but then inadvertently writes something else in the entry. A non-protunct cannot cure the failure to actually make findings. Like I said earlier, there was no mention of 2152-82 in the transcript. In fact, the court essentially reclassified DM through this non-protunct entry. When the court issued this non-protunct entry, DM was over the age of 21, therefore the court did not have jurisdiction to reclassify him. When the trial court classified DM, it didn't make a finding that he was previously adjudicated of a sexually oriented offense, which I've said is a necessary prerequisite to classification under 2152-82. Because the trial court imposed DM's classification without the authority of law, his classification is void. And if there are no further questions, I would like to reserve the rest of my time.
I
Oh,
have a
yes.
question. Are the reporting restrictions more onerous under 82 than 83?
As far as how often
Yeah.
they're the same. He was classified as a tier 3, I believe. The reporting restrictions are the same under the statute. Practically what affect having an 82 classification over an 83 classification, juveniles, and in this case DM did ask the court, juveniles are allowed to ask the juvenile court to be removed or be lowered to a lower classification. A reviewing court might be less inclined to remove him or lower him from the classification if they find that he had a previous offense, or if this was his second offense. So while the tier requirements, the reporting requirements are the same, it could have a negative practical effect on DM in the future.
Okay, thank you.
Thank you.
Good morning again, Your Honors, and may it please the Court, I'm Vince Bellucci from the Medina County Prosecutor's Office, representing the appellee of the state of Ohio in this matter. Your Honors, I believe the parties agree on the initial point here, which is that at the time DM was classified as a sex offender, a mistake was made, both on the record and then in the subsequent classification order. The court mistakenly referenced Ohio Revised Code section 2152.82 instead of 2152.83. There was one number that was out of place, basically one numeral. So because DM had not previously been found delinquent of a sexually oriented offense, .83, not .82, actually is what applied to DM. The disagreement comes when we talk about what that mistake actually means and whether it resulted in a void or a voidable order. And that's very important, as you'll see in a second here. The state of Ohio argues, and the case law all supports, that this mistake resulted in a voidable, not a void order. The mistake is not a substantive one. It really amounts to a clerical error. And basically DM is recently now...
I'm sorry for interrupting you. Then we have to assume that the trial court at the hearing made a clerical error, him or herself. That doesn't sound like a clerical error, does it? I thought a clerical error is just what you don't usually hear of the judge making a clerical error.
Yeah, and
at a hearing.
I understand what you're saying, yeah. And what I would say is, if you look at the entire context of the transcript of this original hearing, you'll see, and I think we would agree, that there's never any discussion about DM previously having been adjudicated of a sexually oriented offense. And that would lead you to believe, if there had been, then he was thinking, you would have to believe he was thinking .82, and he was thinking the whole time, but he wasn't. He knew that DM had not previously been adjudicated of a sexually oriented offense. He was operating under .83. He simply misspoke on the record and said .82. That's a very easy mistake to make. These two statutes are very close, and I think it was pointed out that there's no difference in how you classify based on these. The only difference is this one line that says whether there's been a previous adjudication or not. And I would,
Well, there's no doubt that would be error, but it's just a matter of whether it's error that is correctable by a non-proton.
right, and the non-proton, I think we also would agree with the appellant, with DM's counsel, that the non-proton in this case was not appropriate. And a non-proton is clearly meant to fix something that was stated correctly on the record and then incorrectly in journal entry.
Well, the non-proton is really a clerical error.
Correct.
And that's why I was getting a little confused when you said the clerical error.
I guess that's probably not the best way to describe it.
All right, I'm not trying to put words in, I'm just trying to figure it out. That's all.
I would say more, I guess, misspeaking on the record. The clerical error then occurred when it matched what was said on the record in the journal entry.
But that wasn't an error, was it? It wasn't a clerical error because that's what the trial court said. I mean, this is, when I was reading it, my head was spinning, quite frankly, because I'm like, well, wait a second here. When the court secretary typed it up, she didn't make an error, right? Or he didn't make an error, I don't mean to imply that it has to be a female.
I'm not sure. I guess it could be surmised that she was perhaps listening to the transcript and
I
drafting
would
the
hope
order
so,
based on that. I don't know that actually is what happened, but I'm guessing that's normally what happens.
Well, you're supposed to transcribe what exactly happened in court.
Yes.
Well, just to make matters a little more muddled, that's possible.
That's possible.
Is the order that the court, that is appealed from, an appropriate order, a final order, in that it does not, or at least an argument can be made that it does not set forth the rights and responsibilities of the parties fully, but rather just says, this is what was intended.
Now,
I know we've had some cases where we've gone back and forth and said, that just saying, I didn't mean to say this, I meant to say that, without integrating that into an order, may not be final and appealable.
and I think that's probably correct as well, Your Honor, because it's important to note that the non-proton is not actually what's being appealed here. In fact, it could not be appealed here. A non-proton relates back to the original classification entry, so that would be untimely. What's actually been appealed here was the denial, the trial court's denial of this DM's motion to vacate, which came 6 years after the original classification order. And the most important aspect of our argument, though, and it goes to this Supreme Court Fisher case, it has to do with, it tells us when a sentence is void. And a sentence is only void in 3 situations. If a trial court fails to impose a statutorily mandated sentence, which there wasn't a statutory mandated sentence here, the trial judge has wide discretion to do whatever tier he wants in juvenile court. Does the court lack subject matter jurisdiction? There's no argument that there was a lack of subject matter jurisdiction here. Or the court lacks the authority to act. It didn't lack the authority to act here. Just because it stated .82 instead of .83, it didn't somehow divest itself of authority to act. And I don't think there's been any argument that there was any lack of authority to act. And that's what distinguishes the cases that DM cites from this case. In those cases, specifically this case, this court's ruling in Ray HP, the 9th District case, that case is highly distinguishable because in that case, the court lacked the statutory authority to classify the juvenile. And it's a very clear case where it's kind of a quirky statute, this .82. If you're going to be sent to the Department of Youth Services and also classified as a sex offender, you cannot be classified until you've already gone to the Department of Youth Services and then been released. In that case, in HP, the court attempted to, without any statutory authority, classify the juvenile before they were actually sent to the Department of Youth Services. That is a clear lack of statutory authority. That's a void order. Res judicata doesn't come into play. This could not be further from that. This was a mistake, I'm not a clerical error, but a mistaken statement of .82 on the record as opposed to .83, when it still did have the statutory authority under .83. The court just said .82. And it's important to note that DM was not prejudiced in any way by this mistaken reference to .82. That's why defense counsel did not object to it at the time on the record and did not appeal at the time. And there was actually a motion for declassification filed 3 years later, and this issue still wasn't brought up. DM's clear Tier 2 classification was actually agreed to at the Fulton County adjudication hearing before the case was even transferred to Medina County for disposition. So there was absolutely no prejudice here. This mistake was harmless error. But now, once we've established that we have a voidable and not a void order, this is the big point, we get to the inescapable conclusion that DM's motion to vacate originally was barred by res judicata. And the Fisher case additionally informs us that while res judicata does not apply to void sentencing orders, we know that, it does still apply to voidable sentencing orders like we have here. And we know that DM was represented by counsel during the original classification hearings. Could have been raised. This .82 versus .83 issue could have been raised during the original classification hearing. It was not raised. Could have been raised on direct appeal. It was never appealed. There was no appeal filed. So 3 years later, we have this petition for declassification. We still have his counsel not raising this issue. Now, in late 2015, DM finally raises this issue, but it's too late. The matter has been long barred by res judicata at this point. And like I said, with regard to the non-pro-tunc, I think we agree that non-pro-tunc was not appropriate because it actually, the order, because the mistaken order matched what was said on the record. It was incorrect both times. Again, the non-pro-tunc is not what's being appealed here. But what the trial court, in the state's opinion, could have done and should have done in this case was simply deny the motion to vacate based on res judicata, and did not even have to get into a non-pro-tunc or do anything like that. Also, I believe it wasn't a final appealable order, so I think it's also barred on that procedural ground. Therefore, the state of Ohio would request that this court affirm the judgment of the juvenile court based on res judicata. In the alternative, this court does have the power, I would mention, to modify the order theoretically itself if it found that the case was not procedurally barred, which it is, by res judicata, but it could modify the order itself theoretically to read .83 versus .82. There is an issue down below with the court, with this thing being remanded, it really could not be, because we also agree, I think, that the juvenile court would no longer have jurisdiction over DM, him having turned 21 a couple of years ago. So, if there are no more questions.
I don't think so. Thank you.
Thank you.
Okay. Right. You may proceed. You do have, let's see, 5 minutes remaining.
I just wanted to clarify an earlier point. I said that DM was classified as a Tier 3 originally. It was classified as a Tier 1 originally. The state agrees that this error cannot be fixed by a non-pro-tunc. It can't now, and it couldn't then in 2015 because DM has been 21 since 2015. This court has always held that the failure to classify under the correct statute renders a classification void. The state argues that HP and AK are different because both youth in this case were sent to DYS and that the issue was a timing issue. DM was not sent to DYS, but we are not saying that there's a timing issue. Both the timing issue and the issue with classifying under the wrong statute are independent grounds for finding that a classification is void. The state also cites to State versus Fisher. If you read on in this case, the Supreme Court of Ohio said that Ohio law has consistently recognized a narrow and imperative exception to the general rule. A sentence that is not in accordance with the statutorily mandated terms is void.
But didn't you also state that there was no difference in the sentence from the 82 to the 83?
The tier requirements are different than the whether to classify requirements. So a juvenile court can decide in some cases whether to classify a child. Some children are mandatory registrants, some children are not. So determining whether to classify is contained in 215282 and 215283. The tier requirements are located in a different statute. Where did I get that right now? But does that answer your question?
Sort of, but not exactly.
So
She's really getting at housing prejudice. What does it really matter if he's classified under 83 or 82?
So, like I said earlier, a reviewing court can look at DM's records and decide whether to take him off of the registry altogether before his reporting requirements are up. If they see he was classified under 215282, they would assume that he has a prior adjudication for a sexually oriented offense and would be less likely to declassify him, incorrectly assuming that he has priors.
So wouldn't he have to come back to the court and ask to be reclassified and have the court say, no, we can't do that because of you're at .82, but then he can appeal and say, yeah, but I really should have been .83. That's not why we're here.
Right. He did ask the trial court to be removed from the classification, to be removed as a registrant in 2012, and the court denied.
Because of the 82.
I'm not aware of the exact reasoning of why they denied. If there are no further questions, we respectfully request that this court reverse the juvenile court's decision and vacate DM's classification.
Thank you very much.